What's up, everybody? Welcome back into another episode, another week in Karen Reed's second trial, where we finally get to hear from the accident reconstructionist from the Commonwealth, the new and improved accident reconstructionist, not Trooper Paul, who's going to tell us whether or not a collision occurred, how the collision caused the injuries to John O'Keefe, and how this is actually a crime that they can prove Karen Reed committed. So did we get that today? Are there issues? What can we expect with the rest of this expert's testimony as he did not finish today? All that and more. And of course, we're going to answer your questions. Make sure you hit the like button. Let's get to it. So before Dr. Welcher even took the stand, there were a lot of issues today. A lot of long sidebars, a lot of stoppages, a lot of we've got to deal with this, a lot of expert testimony stricken that is just not really normal with experts that we've had all of the arguments with, like we have in this case, coming up to trial today. So it was kind of a clunky day overall, which is not great for the Commonwealth when this is your star witness and you need him to be your star witness. But whatever the first sidebar was and argument was with all of the lawyers up at the judge's bench ended with Alessi basically getting a quick voir dire of Dr. Welcher and talking about who he spoke to about his PowerPoint. His PowerPoint has changed again. He ran through it twice with Brennan. He met with Tully. Tully drove him from the airport to the DA's office. He also met with Lally and some other people that he talked about. But let's listen to just a couple minutes of Alessi's questions, which will give us an idea of part of the cross-examination that I think is going to happen tomorrow. And then we'll dive into what Dr. Welcher actually testified to in this trial today.
Pick me up at the hotel.
I'm talking substantive, sir, about your outline, your PowerPoint presentation. With discussions about the topics in your PowerPoint presentation.
I had no discussions with him about the topics of my PowerPoint presentation.
Who did you have discussions with from the Commonwealth about the topics in your PowerPoint presentation?
Mr. Brandon and Mr. Lally.
Describe those conversations and how many you had, including the first one that you had.
Well, I originally submitted my presentation with my original report way back, I believe, in January.
Right. I'm asking for conversations within the last 2 weeks.
Okay, question wasn't clear.
The question wasn't clear. You basically got right off the jump with this voir dire how the vibe was going to be with this witness, right? And you never know with experts. Are they really going to push for one side or the other? Are they going to try to seem as neutral as possible, regardless of if we think they are, right? How are they going to come across? And the very beginning of his testimony and then the very end were the two most highlighted portions of the problematic nature of the way he testified. I don't have as huge of an issue with some of the stuff that maybe you guys do throughout today, and we'll talk about it and talk through it. But some indications for sure that he was going to try to push the Commonwealth's narrative in any way, shape, or form that he could.
And on Sunday, we just went through top to bottom through my presentation. Mr. Brandon wanted to make sure he understood everything in it. And then I met with Mr. Brandon again on Sunday. We ran through it briefly again. And then that was largely it.
Who suggested the changes to your presentation?
Mr. Brandon.
Mr. Brennan suggested the changes that you make.
He indicated some of the things, for example, the slide I deleted referenced testimony that I was not allowed to include on a slide.
So Mr. Brennan suggested you change your PowerPoint. Isn't that interesting? And when, sir, did you change your PowerPoint?
Were there any discussions with anybody from the prosecution team about the changes with regard to the what I would call the Dighton route, the Dighton distance, and the total mileage? Do you know which slide I'm referring to, sir?
I do, yes.
Who initiated the discussion on the changes to that slide?
So that slide was changed, I don't know, probably 8 or 10 days ago.
Oh, it was changed 8 or 10 days ago.
Correct.
Unless he's like, oh, really? 8 or 10 days ago. I wonder why Brennan didn't turn it over then. It sounds like he didn't. I don't actually know if he didn't. Maybe he did, unless he sounded surprised. I think 8 or 10 days ago is probably when we were arguing about some of the Shannon Burgess stuff, which was also late disclosed, and arguing about that and saying, oh, Judge, wait, there's more. We have another expert that has changed their, report, PowerPoint, whatever you want to say, what they're going to present to the jury. That's problematic. And it's just, at this point, the Commonwealth knows they can do it. They know they can get away with it. They know the judge is going to allow it. So who cares?
Were there any changes made from 8 or 10 days ago to what's now in your presentation?
Not beyond what we talked about.
Oh, okay. So 10 days ago, those changes were made.
8 to 10
8 to 10.
days ago. I could actually probably figure out exactly when if you like.
Now my next questions go to Mr. Burgess. Mr. Burgess is a colleague of yours at Aperture, correct?
Correct.
Are you aware of issues relating to the accuracy or inaccuracy of his CV?
Unfortunately, I've been bombarded with emails that have referenced that. I've seen it. I have not read them.
Unfortunately, I've been bombarded by emails about his CV. So is Alessi going to get into it because he's so high up at Aperture? And we found out that he started his own accident reconstruction firm and they were either merged or bought by Aperture. So he's pretty high up there. He works out of California, but does some work out of Texas. I think Burgess is out of Texas. So what did you know? What should you have known? He's like, well, I got some emails. I saw the titles and then I stopped reading because I knew I wasn't supposed to.
You've been bombarded with them, but you have, and you say unfortunately, but you have not read any of them? None?
Maybe 1 or 2 lines. For example, they come in, they're looking like legitimate business emails. And then I pull it up as a business email. I'm like, okay, I'm not supposed to do this. Court said I can't look at this.
Now, I want to go back to your slide presentation. I understand that you intend, subject to our objections to the court's ruling, you intend to present testimony with regard to your PowerPoint where you are going to elaborate on your 1231-38 to 1231-43 trigger 1162-2, and you're going to add to what has been in your presentation a verbal discussion with regard to Mr. Burgess's change that he made in his May 8th report with regard to the variance time window. Do I have that correct?
No, you don't. It's not based upon a verbal discussion. It's based upon his report.
Okay, so you're going to make, you propose, what you're intending to do is you want to add the change from Mr. Burgess's May 8th report to what you're going to testify to on your PowerPoint. Do I have that correct?
That is correct.
And the only reason you're going to testify with regard to altering the 1231-38 to 1231-43 window is because of what Mr. Burgess has done on May 8th. Is that correct?
It's better data. So I'm altering it and correcting it with better data.
It's better data. He's getting better data. The new and improved Burgess report, which is why it's so important. If they didn't have better data prior, it matters. And that's the thing where it's just like makes my head kind of spin. And this is a minor issue as we get through the rest of the day. But for people that just act like this stuff doesn't matter and is unimportant and it is what it is, it's like, then why they need to do it? Why is it better data? If it helps their case and they didn't do it until now, and they had this information before now, and they didn't even notice it till we brought it up, and they're making it look like they are competent when we were going to prove they're not. All of that stuff matters. Credibility matters.
That I've received from Mr. Burgess.
Right. But my point is, if it weren't for Mr. Burgess's change, you wouldn't be making any changes in your testimony, correct? It's only because of what Mr. Burgess did on May 8th. Is that correct?
Only from his report, correct.
Correct. So, and you understand, sir, that change has significant effects on the very issues in this case with regard to the timeline and the collision you allege occurred, and comparing it to human volitional conduct of Mr. O'Keefe with regard to his manipulation of the phone. You understand the consequences of that change, do you, sir?
I do. I would disagree with your assertion that it's consequential. Again, my original data, which is in my PowerPoint and has not changed, that data is still there. The timing was extremely close within the error of the measurements, which Mr. Burgess ultimately showed in his subsequent report that was within the variance associated with those timing devices.
I understand.
So here's my ultimate ending to that would be, then why did you have to change it in your report? Why don't you just leave, 1231 and change and say it could go up or down? And that's just leave it what's in your report as opposed to changing it. That's one of the problems that I have with all this. And it's like moving the goalposts and shifting things around as the prosecutor is problematic in my opinion. Okay, let's get to the bulk of the day. What did Judson Welcher have to say? I thought he had a very, very impressive resume, the type of resume you want for your biomedical engineer, accident reconstructionist, or biomechanical engineer. Whenever you hire a witness like this, you want his resume to look like and to sound like Dr. Welcher. Dad was a doctor, told him not to go to medical school, and he liked to take things apart even though it pissed off his parents. Like all that stuff, I thought the educational background. By the way, Hank Brennan did decide to ask him about where he went to college and where he got his education and talk about your PhD. No surprise there. And I thought it was a good resume. I thought that's kind of what you want. He also talks about how he testifies for the plaintiff, the defense, the state, and the public defenders. I don't know if that meant anything, private defense attorneys versus public defenders, or if he just meant also for the defense. He has no dog in the fight, doesn't care, just came here to do his job. Aperture actually has offices in Massachusetts, which I thought was important to get out through this witness. And Texas, of course, he's in Long Beach, California. He considers everything he looks at, but doesn't necessarily consider everything he looks at to be reliable. To me, all of that is important. I also think this was a good job by the Commonwealth, even though I kind of disagree with the premise, but let's when you have it, you flaunt it basically. And so it's no surprise they did. I'll tell you what my beef is, just like some of my own cases when something like this happens.
To look at what happened to the cars, meaning to actually look at the cars, not just look at photographs when possible. So I have physically looked at the cars. For example, on the Lexus, I climbed in it, over it, underneath it. I downloaded data from it. I did a whole bunch of things looking at Ms. Reed's Lexus to assist in my analysis to try and add some further objective data to what we're doing here. So same thing with Mr. O'Keefe's vehicle. Looked at the rear bumper, took some pieces off the rear bumper to see what was behind the cover, to see what kind of damage we did or didn't have. So went to the scene, looked at the measurements of the curb, looked at where some of the lines are on the road because you can see them in some of the photographs. Again, it's always good when possible to inspect everything you can inspect.
So that sounds good, right? That does sound good. Here's a problem with his own theory is there is always more information and material that you can inspect that you don't inspect, right? And we'll get to that when we get to his demonstration and what he did and what he could have done differently. But ARCA's going to say, I looked at pictures, right? He knows that. ARCA's going to say, I didn't inspect the vehicle, which I don't think they did. We'll see what they actually say. But I know last time they said it wasn't necessarily necessary for them to inspect the vehicle. But when you have an expert that takes the extra step and does something, whether it's necessary or not, lawyers always want to highlight it because some jurors will absolutely make that a differentiating factor. For example, we have defense experts in some of our cases. Let's say it's a lower back fusion and they've complained about lower back pain. And they're like, well, you didn't look at their pediatric records from 40 years ago and we did. And it's always important to look at that. It's like, well, did they talk about back pain? No. Well, that could be significant because they didn't have back pain back then. It's like, okay, but you're saying that's significant to now, or gynecology records for some of our female clients. They want to get those. We object lots of time. We're like, Judge, that's completely irrelevant. Depending on the judge, sometimes they allow them, sometimes they don't. They're like, well, you didn't complain of back pain when you went to your, normal checkup with your gynecologist. It's like, we don't usually talk about neck pain or back. Sometimes you do talk about back pain, especially with pregnancy. I get it. I'm just saying, generally speaking, let's put it this way. The eye doctor or the dentist, sometimes like, well, we looked at the dental records. They didn't complain about lower back pain. It's like, well, you don't complain about lower back pain when you go to the dentist. You go because of your teeth. But sometimes experts will say, well, we looked at everything. We looked at all of the records, so we know more. And this is one of those scenarios. Will a jury find that to be more impactful? This, to me, is a lot closer to being relevant than some of the examples I gave. And I actually think some of the jury will think that this was better. He actually went. He looked at the Lexus. He took measurements. He did all of that. And ARCA did not. So should we trust and believe him more? That's a big question. What will they think? What will they say? He explained all the things he looked at for the investigation. People have, are taking issue with the fact that he said he watched interviews and read this, read that, read the police reports, did the testing, looked at Burgess's report. But basically, he reiterates the entire Commonwealth case that he took all that into account, which again is going to be important with some of what he says later. He looked at where the lower rear taillight was, no damage there. I think he said it takes 6 to 7 minutes in good weather to get from Fairview to One Meadows, which again, we've got to try to figure out how important that is in the timeline. And are they going to deal with that? And are they going to disprove that as a reasonable doubt? Because this is theoretically their last witness. We'll see. And then he got to something that I've been wondering the entire trial. And a lot of you have too. It's like, why did we not have a triggering event if there was a collision with John O'Keefe? And he explains it. And I actually think this is probably the correct explanation. And he probably is right about this. So let's listen.
This system is primarily to manage the safety components, protect the occupants of the Lexus. So things like fire the airbag, fire what's called a pretensioner, keep track of the severity of the crash to decide whether we need to fire the airbag. So it's not really designed for pedestrian impacts. So when we downloaded this vehicle, we got what's called a none file. A none file simply means that there's no data there. The system's working properly. We had no fault codes. But for a car hitting a pedestrian to cause a file here, this is really more designed for car-to-car impacts, something that's going to have a significant impact on the occupant of the Lexus. And again, the Lexus is
something that is going to have a significant impact on the Lexus. So you each individual person watching this right now, each individual person on the jury is going to determine for themselves what they believe a significant impact to be. I had somebody who said, a potential juror in a case, that she would only award money for really serious injuries. And we were like, okay, what do you consider a serious injury? And she's like, paralysis. We're like, okay, we would agree. Would you consider, broken bones all throughout your body a serious injury? She's like, no, not really. It's like, okay, I would consider broken bones a serious injury, but let's keep going. And we kept discussing it because it's very different what each person, one to the next, considers a very significant injury or impact like he's discussing. And he says it's only going to pick up significant impact. So is he admitting this was not a significant impact?
something that's going to have a significant impact on the occupant of the Lexus. And again, the Lexus is 6,000-pound vehicle. Mr. O'Keefe's only 216 pounds. So it's not going to register from hitting a pedestrian.
Were you surprised that they would?
It is not going to register from hitting a pedestrian, which, just FYI, I think that's plausible. I think he very well may be right about that. That is very believable to me. But can you smash the back tail light without a triggering event? If something is strong enough to smash the back tail light like that, would it not be a triggering event? Would that not take a significant impact? And that was so frustrating for me today to listen to this, because I've really been waiting for this. I really want to see how he could put all this together. I really want to see how he would explain how the impact could do this to John O'Keefe's arm and smash the tail light and, twist him, push him, make him fall backwards without, breaking other bones or internal bleeding or bruising in other places besides on his knee. Like, I really wanted to hear how he was going to explain all of that. And he explains significant impact, says this was not a significant impact, but does not explain how a non-significant or insignificant impact could cause the taillight to explode. We haven't heard that yet. He's not done, but this would have been a good time for it. He talks about how he looked at John O'Keefe's vehicle. We'll talk about that. Triggering events, 8 minutes apart. Oh, this was interesting. When he starts talking about Burgess's report a little bit.
Understand that's a clock in the infotainment system. And then we are ultimately trying to also tie it back to the clock on his cell phone. Mr. O'Keefe's cell phone, correct.
Do you have any understanding whether all devices have the exact same clock?
So it's my understanding they do not. In my discussions with Mr. Burgess, reading reports, that there can be as much as 30 seconds to a minute of variation.
Objection, Your Honor.
Sustain.
Have you ever heard
Strike, Your Honor, that answer.
Sure. Jurors disregard that answer.
Have you ever heard the term variance before?
I have.
What do you understand that to be?
That means differences from the answer,
I'm sorry, differences from what?
from typically the correct answer. Like meaning that
I like differences as a lawyer, right? Who's asked experts these questions before. I like differences from an answer better than differences from the correct answer. And Brennan didn't hear that. I don't think, again, multiple times throughout this trial, and it happens to me too sometimes, so I'm not just hating on any of the lawyers here, but when an expert gives you an answer you didn't expect and you're trying to fix it and you ask them to clarify and it gets worse, that's, I feel like, what just happened with Brennan in this witness, where he was like, oh, you said difference in the correct answer is the variance, which means you guys didn't have the correct answer before. Yes, Rebecca, thank you so much for that. And if everybody subscribes, we get to 500K. Here's what I'll say, Brian B. If we get to 500K by the end of this week, Friday, by the end of the testimony this week in the Karen Reed case, yes, we'll do 15% off the merch store. Absolutely. Let me answer a few questions. We've got a bunch in here. It seemed like the testimony was was that the 3-point turn happened on a street that wasn't Fairview. That's correct. But wasn't the 3-point turn where John was supposedly hit? No, that's not what they've been arguing this trial. It happened before they got on Fairview. Is it possible John O'Keefe threw the drink at the back of the car? Well, the Commonwealth has not really discussed that option. I believe the defense might, but I have not heard that option discussed from the Commonwealth, at least. This is Pin the Tail on the Donkeys, and there are many. Hank, the Weasel, Judd, the Chud, Auntie Bev, all working blindfolds. Where else do you wear a freaking blindfold? I know where. We're going to get to his demonstration. A lot of people are saying, how common is it for an expert to cosplay as the victim? Not common. They usually use like assistants or stuff in those situations. We've had, again, some of these accident reconstructions. We've had some drowning cases where they put a dummy in the pool and see, what can a lifeguard see? What can they not see? Different, perspectives like that. And usually they're not the ones to do it. I don't think that illegitimizes it on its own, though. I know a lot of people do. I would not say that illegitimizes it on its own. Is it normal for an expert testimony to be struck so much? No. That struck me as abnormal. It happened a lot to this witness. I actually made a note of it when I was taking timestamps. C. Logan, what if the dog broke out of the gate and knocked John O'Keefe down? I think that's a possibility. I do think that's a possibility. I think that fits with all the Commonwealth expert. They have to explain to us how it's not. And you know how it's not? If a car hit him. This is not something that's reasonable if they can prove the car hit him. BG, can attorneys be watching trial streams, online reactions during the trial to better understand the possible juror perspective prior to cross-examination or recross? Depending on the jurisdiction, yes. Some courts allow that. We heard from Doug Weinstein from the Young Thug trial that he was doing that. So some do. Some do. Okay, let me see what else we got here. 1223, 3-point turn. Talks about when and where he did the 3-point turn. I don't think we need to get into that again. Talks about the time variance. How fast was she backing up? The 74% throttle, 0 brake. This stuff I thought could be important, right? Because if they can prove she was really hammering the gas going backwards, and the little demonstration they do here, I thought this could be effective potentially. Talking about how she went in reverse, connecting it with later that John O'Keefe was actually hit by the back of the car.
And how do you do that?
So we have accelerometer data. We have velocity data or speed data back here. I've corrected for what you see down here is, and I go through this on a later slide, but right here you can see a significant increase in the RPMs, but yet the acceleration is dropping. So what that means is if your RPMs are going up and the speed's going up, that means you should be accelerating more. But what happens because the acceleration is dropping, that means what's actually happened is the wheel's slipping. So what I've done is I've used the accelerometer's data to calculate the speed once the vehicle is put into reverse. And once we know the speed, again, feet per second, we know every data point is half a second. So speed times time tells you how far you moved. Feet per second, feet divided by seconds times seconds gives you feet. That's how far you went. So you get how far you went in each interval, then you get the total distance traveled. And so this is relative to the start. So 0 is the start. The vehicle goes forward about 34 feet. Then you see it basically stops in this area here, then begins to back up and ends up backing a total of 53 back from where it originally started. So if you add 53 to 34, you get 87. So the total motion, 34 forward, 53 back, the Lexus moved 87 feet total.
Dr. Welch, when you say the Lexus moved 83 feet total, is that according to the data or is that the entirety of the movement of that Lexus?
No, that's just from when the data starts to when the data ends. So if you look at when the data starts,
which I thought was also an interesting concept, how he said basically the vehicle could have kept moving after the data ends, which is like, okay. Christy, here's a good comment. Peter, I've been a long-time follower and I respect your fair, unbiased views. You've changed, okay? I love that you've changed. It's like, I promise you I haven't changed. You're acting like all the evidence the Commonwealth has is invalid and not good enough. I completely disagree with you. And I'm literally going to talk about part of his presentation that I thought was awesome and that I thought was very convincing. Here's the problem. The Commonwealth is coming to the end of their case, and they are woefully short of proving this case beyond a reasonable doubt. If you disagree with me, that's fine. That's fine. But I've done this on every single case. I've said whether or not I think they've proven the case beyond a reasonable doubt. Then we hear from the defense to see, can they create reasonable doubt or highlight reasonable doubt, things like that. But this is how it's supposed to work. The Commonwealth or the state or the government, the prosecutor is supposed to force you into the guilty pack during their case in chief. Then the defense goes. Okay. Then the Commonwealth gets to go again and rebuttal. And it is their job to do that. And in this case, I'm not saying all their evidence is invalid at all. I have felt like some of their witnesses, I feel like, have made points, but it has not been good enough. Like you said, it is not good enough to me. To me, could be to you, could be to you, and it could be to these jurors. And I'm going to talk about how certain parts of his testimony specifically, the parts I agree with, I think some jurors will really like. The parts I disagree with, I still think some jurors might really like them. I do. And you're not going to so this is something people need to stop doing. You're not going to guilt me to change the way I think about or talk about this case by saying I've changed. That's not the way. You want to change my opinion or the way I look at this case? Tell me why you think they've been good enough. What evidence have they presented that's good enough? How have they convinced you beyond a reasonable doubt that this is what happened? Please tell me that. Put that in the comments. Not you've changed, not, oh, you used to be so much better because I used to agree with you. We can save that. Tell me why you see it differently in this case, and let's talk. Ben has done that. John has done that. Multiple people have done that in this chat, and I love it. I love to read it. I don't want any hate for any of these people, but tell me that. That's what I want to hear. That's what I want to hear. Okay. Let's see. Next, I wanted to play a little bit more of this.
You can see that the vehicle is actually going 13.67 miles an hour. When the data stops, the vehicle is still going 23 miles an hour. And you can see,
I'm sorry.
you can still see that it's still at 74%.
So 74% throttle, zero brake, 23 miles an hour sounds like you want to back up and hit somebody potentially. Slamming on your reverse gas, right? I actually think that was good, Christy. I actually think that was good. Good job by them. That sounds nefarious. That sounds bad. Why are you doing that? Now I can think of a couple reasons. You're mad and want to get the heck out of there. You're going to hit somebody. That could be a reason, right? You don't know where you're going and you're backing up. You're drunk, right? There's all sorts of reasons that you could do that. But I think that's good evidence by the Commonwealth. And I think based on what the data is showing here, I'm walking with him through this.
Throttle. So, this is 3/4 of full throttle in reverse.
So to start with the distance traveled, if you can go to the top, we see that the speed is 13.67. Is that where the data gets picked up?
That's where the first data point is. Again, the trigger is here. This is 5 seconds before the trigger.
Are you able to tell how fast or slow the vehicle is traveling before that data point in 5 seconds before the trigger?
No.
And likewise on
the data just doesn't exist, which sometimes, listen, fair or not, if the data just doesn't exist, sometimes that's just bad for the Commonwealth and it's bad for the state. There are some cases, I'll just tell you, there are some cases you don't even need this data. You don't even need to know when they're backing up. You want to know why? Because it's very clear the person got hit by a car. We've had cases where the tire tread is shown on somebody's back. We've had cases where there's internal bleeding all down the side of their body and bruising all down the side of their body where the other side doesn't even argue that they were hit by a car. But when you need these types of data points to prove that John O'Keefe was hit by a car, they are important. So when they don't exist, sometimes that can be the difference between proving the case beyond a reasonable doubt and not.
Bottom, the speed. At the end of the 10-second data points at 23.61, can you tell whether or not that speed stayed the same, increased, or decreased?
I mean, considering you're 74% throttle, it likely increased. How much, I don't know. And you can see that up here, she's on the brake. Down here, she's not on the brake. And so she's not on the brake and at 74% throttle.
And what is the percentage of throttle that has to be initiated to cause a triggering event?
For a shift into rear and a rapid throttle application is 30%.
If you look at the next column over, if you can go to the top heading for the jury to see the engine RPM data, could you explain that?
Sure. Again, that's the engine RPMs. And so, as I mentioned, you have this jump in engine RPMs and a very dramatic jump in the reported speed of the vehicle. But when you look at the acceleration is actually dropping. So again, that's a telltale sign that the tire is spinning because the vehicle is not being accelerated. And so I've used the accelerometer data Again, if you just, a process called integration, you integrate the accelerometer data, it will give you the velocity. So what I've done is it's called piecewise integration to get the speed data that takes into account the tire slippage, and from there calculated the speed or the position at each interval going across the top here.
If I could stop you at your column that says JBW speed at each time step.
Yep.
If you go to the bottom, please. So does your data indicate that the speed is changing at the end of this 10-second event?
Objection, Your Honor.
Sustain.
Is the speed changing at the end of this event?
Yes.
How so?
Well, again, you can see it's increased about 2.7 miles per hour. And again, we know from what I already stated that that last time step, you're still at 74% throttle and you have zero brake application.
Is it possible from the data to tell how far the Lexus went forward before it went in reverse in total as far as feet?
Not in total, no. We just have this 10-second window. I can tell you what it did during this 10-second window.
Is it possible to tell how far it continued after the data?
No.
So it could have continued farther. I think that's, potentially could be a good point for them. And again, this timeline, up or down 21 to 29 seconds. Again, that snafu, that problem is annoying because without that, I think the Commonwealth is kind of building out their timeline better. Again, I always have to remember that pesky 1236 connecting to John O'Keefe's Wi-Fi. If we didn't have that, the timeline for the Commonwealth would be really good here. But even with that, the backup event coinciding with John O'Keefe's phone, never having any more human activity being ish the same time, I think is a good timeline. So explain to us how he was hit by this car. Where did the car hit him? How did it hit him? That's what I've just continuously been waiting for.
The shift position changes from 1 to 0 to 2. Can you again explain to us what that means?
Sure. 1 is drive, 0 is neutral, 2 is reverse. And then brake switch status. Again, a 1 is you're on the brake pedal, enough to activate the brake lights. 0 is you're off the brake pedal.
Each one of those indicators, 1, 0, 2, how much time is for each of those?
0.5 seconds.
So can you tell how long the Lexus was in neutral for?
So again, it only occurs at 1.
All right, we're going to jump to the next part, which is a little simulation about how he shows what this would look like. Just after lunch here. And again, I liked this demonstration. I liked a lot of the demonstrations, not all of them. I liked a lot of the demonstrations that he did. And from my perspective, this was also a good kind of showing how she went forward and then backwards and the left turn, towards the curb. I thought this was good. It helps you visualize it. It helps you picture it, which is really important.
Response to the Lexus. So this is to show what it represents on the left-hand side. So each one of these little hash marks, different color, represents 10 feet. The red lines show the extent of motion. Remember what I said, initially pulled forward, then backed up, past its initial spot, and then went backwards further distance. So what this shows is where we simulated this in a program called HVE. So that's the vehicle, the Lexus pulling forward. And then it accelerated in reverse, past its initial starting position, and came to rest right there.
Doctor, when you say it came to rest there, do you have data that the defendant's Lexus stopped there?
No, it did not come to rest. That I misspoke. That's where the tech stream data ends. As you can see here, it's still going.
So Trevor, I think that they have done a good job dispelling that as a reasonable doubt, that this was when it was put on the tow truck. Trevor said tire spinning. That trigger sounds a lot like they towed the truck. First off, it was put on a flatbed, I believe. I don't think it was towed with his back wheels on the ground. I actually feel like that's something they've done better. This trial is showing that's not when it was. But again, we can differ about that too.
It's still going approximately 23 miles an hour when that ends.
You'll have to zoom in on that so the jury can see what you're referring to. Please.
So again, as I mentioned, the tech stream's taking a window of data. It doesn't take anything outside the window. You can see that when we account for the wheel slippage, that the vehicle at the time of the last data point, again, is at 74% throttle, 3,300 revolutions per minute, and is going backwards approximately 23.9 miles per hour. And you can see it's traveled a total distance backwards of 53 feet back from where it initially started. Or if you consider.
We don't need to do the math again, but generally, again, I think they kind of made their point there with that. Then we get into, And I want to do this kind of quickly, but I also want to show you what he did here, because this is what I expect from an accident reconstructionist like him. Okay. So when we get into Karen Reed's car hitting John O'Keefe's Traverse, he agreed they made impact. He agreed it was enough impact to knock the snow off, but not enough impact to break or damage her taillight, because you would need more of an impact than what he had. We have the Ring camera that shows exactly what happened here. So he has that. Okay, I'm going to turn the volume off. I'm just going to kind of skip through this to show you, what he did, what they have. We have the actual camera. We have the marks in the snow. We saw the part of John O'Keefe's car that it likely hit. And so he went out there with his machines. Let me see if you can see all this. And his lasers and, did all his expert-y type stuff. And they even used the Ring cam footage to show what he was doing, which I thought was great. He makes the measurements. They put the car in where the measurements were. They create a demonstration of what this would look like. They have the patterns of how the car moved. I loved it all. Showed all this. Okay, I get it. I see where her car hit his. They show how it moved across the tire tracks, where the tires were, where they believe the impact happened. He measured on Karen Reed's car to show where the impact happened. It was down near the lower bumper, or that lower tail light, exactly where the measurements are, right? Not estimations, not about here. Let me show you, it might be an inch or an inch and a half off. No, he showed all of that and said, this did not damage her car or taillight. It would not have been in the right position to have even struck and broken her taillight. I think maybe not all, right? Because I don't know. And this was a good comment here too by Mary Claire. I did not connect with this guy at all. I found him verbose and that he was trying to lead the charge. To me, the details came across like a shell game. Guess where I am on the spreadsheet now? Just my opinion. So here's what I'll say. I think Mary Claire is probably thinking Karen Reed's not guilty, right? And she's a juror that's kind of in that camp. And when you hear something like this, you start to understand even the stuff I think is good. Like, I'm looking at this, I think this is good. She's like, no, I'm not buying it, because jurors will sometimes do that. She's a good representative, because other way, jurors that think she's guilty at this point and think the Commonwealth have proved it, when Alessi gets up and is going to cross-examine this witness, they're going to be like, man, Alessi's so mean to this guy. Like, he's just doing his job. 21 to 29 seconds, not that big of a deal. It is what it is. Karen Reed did it. The timeline lines up too perfectly. How else would her taillight have broken? I don't really think all these cops are involved in a conspiracy. And there will be jurors that just stay in that bucket and think that she's guilty and dismiss things as distractors. That's very common. That's very common, especially at this point in the case. Maybe they'll be swayed one way or the other eventually. But I thought his presentation and what he showed, his demonstration, the measurements, and I literally tweeted about it. My tweets got all screwed up because I edited once, so it changes all the times. But this, I thought, was actually pretty good evidence. And you guys can disagree and say his measurements were wrong, and you think this is all wrong. And that's fine. That's fine. That's fine. As I look at this, if he would have been able to do the same exact thing with John O'Keefe to measure up to the elbow, show the impact that it would take to break this polycarbonate taillight, show the impact it would take to rip skin, show how that impact could be in the same variance, right? We like to use that word, where it could be just hard enough to break the skin and not shatter the bone or leave any bruises on his arm, but also strong enough to bust the taillight. Like, that's what I wanted. I wanted the measurements. I wanted the testing. I wanted to see a demonstration of it. That's the type of stuff I wanted from the John O'Keefe impact, which was similar to this. And that's why I thought it was so interesting to get this right before we jump into his demonstration, which we're going to listen to a big chunk of. But first, I want to answer some questions. Alessi is the GOAT. I like what he did on voir dire, and I agree with his arguments at the end of the day. Do you think Bev will agree? Doubtful. I think she's going to give him a robust cross, but I don't think she's going to cut short what this witness wants to testify to. The car must have hit John O'Keefe for any guilty verdict. I think there's no way a jury thinks there was no collision and then convicts her. So yes. Technically, if we want to get legalese and try to really dig into the definitions of certain things, I think it's possible, maybe, but I don't think in reality it's going to happen like that. But did they test an impact with an object consistent with John O'Keefe's height and weight at the alleged speed to see if the Lexus recorded it? It's a great question. It seems like they could have, Jinx. Seems like they could have. So no damage when hitting the car, which I think he did a pretty good demonstration of. Stationary, very heavy object, I agree. But shattered taillight when hitting a person who's likely moving, who also is not big enough to even create a tech stream event on the Lexus. Polycarbonate isn't that fragile. Welcher didn't inspect the car until September 24th. So how would this impact the jury in his favor? I still think inspecting the car is better than not inspecting the car in most jurors' minds. Whether or not ARCA says it's reasonable or not, and it may not be. But like I said, lawyers are going to use that when they have it. Cadavers versus crash test dummies change the kinematics when it comes to accident reconstructionists. Did he discuss this? Not that I remember. I feel like you hear and register so much more than a juror listening at one-time speed plus no ability to pause and reflect. Are we overestimating the likelihood of not guilty verdict? Yes, I think so. I think most people think this is like locked and loaded, not guilty. Now, I do believe it is going to be very difficult to get 12 jurors to vote guilty. But I also think it's going to be much more difficult than people may think watching this, like you said, watching recaps and slowing it down and rewatching things and hearing people's takes on it. People, I think, are a lot more confident in a unanimous not guilty verdict than I would be. How is this guy allowed? It's all junk science. As a medical professional, I was appalled today. I would disagree with you that it's all junk science. I think a lot of this can be measured, can be shown with math and science. Now, did he do what he did here with the Traverse with John O'Keefe? Not so much. Do you think the Commonwealth chose not to call Proctor because they knew counsel thought it would be suborning perjury? No. It just seems crazy they would choose not to get out in front of it with Proctor. I just think they want to act like it didn't happen and hope it doesn't come off as bad if the defense calls him. I do not remember how John O'Keefe was supposed to be thrown back 30 feet. How did going 2 miles an hour prove this? So he's not saying she hit him at 2 miles an hour. I also don't think anybody said he's been thrown back 30 feet, just that he fell back on his head. That's another, exact specific detail that we just haven't gotten this trial. Did he make sure the tires and rims were also the same as Karen Reed's for accurate calculations? That's a good point. He said it was a match, I think. I didn't remember if he got that specific with tires and rims, but that is a good point on these cars. It can be pretty different. Did the Commonwealth ever discuss what caused the arm injuries? When the defense brings up possibility of dog bites, can the Commonwealth call the witness in rebuttal? So yes, they're going to call a witness in rebuttal to say it's not a dog bite, but this witness and what we're about to watch, he discusses what caused the injuries, not only to John O'Keefe's arm, but also to the front of his face potentially. So let's take a listen to this. This was the bulk of his testimony here, his demonstration, what he did, why he did it, to show exactly how this happened to John O'Keefe. Also, a lot of people have come with this comment that dressing like John O'Keefe next to the Lexus seemed powerful, but without actual measurements of the height and rear lights and height of John O'Keefe's arm when bent, adding to the shoes, it just doesn't seem scientific. So for anybody that's, I don't know if I caught this part in the demonstration that we're going to watch, but he said he's about a half inch shorter than John O'Keefe and a couple pounds heavier. So basically he makes the perfect person to use for the demonstration as where John O'Keefe would come up to a Lexus that they bought. That is, they say the same make, model, and everything as Karen Reed's Lexus. Oh.
Air dam would be another. Okay, so I then set about to do a little bit of testing with the Lexus. The first test you're going to see is me just walking backwards or actually sideways into the Lexus. What I've done is I've painted.
So again, just right off the bat. And if people think this is too harsh, it's like, this is what lawyers do. Walking backwards or sideways into the Lexus. Is there any evidence that's what John O'Keefe did? Any evidence at all that that's what John O'Keefe did? So why are you doing it?
The Lexus right rear taillight with what's called grease paint. Kind of sort of like paint, but it doesn't dry. And then I have backed up sideways, side shuffled into the Lexus with my arm out, see what the damage pattern looks like, or basically where someone of Mr. O'Keefe's height's arm would contact the rear taillight.
So many interesting things, right? If you want to take this apart and pick this apart, which I understand if you do. So he ends up towards the back seat, right? With the way that he rolled out. So show me a demonstration how it's even possible to end up and for all of the parts and taillights and shoes and bodies and cars to all be moving to end up where you say, the Commonwealth, that they ended up after this collision? That's something I'm struggling to really follow with what they're doing.
So then what you see is I've shown the photographs again. I show the paint transfer onto my arm. The yellow grease paint on my hand was to show where my hand would hit the taillight. And so just kind of me walking slowly sideways into it, the approximate location of the taillight, and I'll line it up with the broken taillight. And
It's also like, just to shatter a glass or to break a glass could take a certain, speed. Also, the glass could have just hit the ground and broken, right? So holding it in your hand, there are certain things I think would be important and certain things I think are less important. And it really, I mean, the blue paint and then showing John O'Keefe's arm at the same time to act like, because the paint ends up in the same region as the injuries to his arm, that proves that the taillight could break and make those scratches, is beyond me. Beyond me. Now, I do think they did something better than the first trial, that at least we can see somebody of John O'Keefe's ish height and weight, could his arm, and I've always believed this to be true. I just thought Trooper Paul did a horrible job explaining it, that it's possible that this part of his arm could be at the same level as the taillight. He did at least prove that. I do think he at least proved that it could be at the level of the taillight. This should have been step one out of like 25 things that he was to prove, that how that injury could actually be caused, and not just that injury, but just that injury, right? Not just the injuries he did sustain, but the injuries he didn't sustain. Explain to me how that's possible. I expected that out of this witness, and we just didn't get it.
the second lines up with the approximate location of the lacerations on Mr. O'Keefe's arm.
Dr. Welch, let me ask you a question. When you're engaging in these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No. So we don't know exactly how he was struck. And pedestrian impacts are extremely sensitive to exact angles. And so where exactly your foot is, whether your foot's off the ground, can have an effect on where you end up after that. We just don't have enough information in this case to determine all that information. We know the taillight was broken. We know the glass was broken. We know we have damage to the rear of the Lexus. We know we have lacerations to Mr. O'Keefe's arm. So I'm trying.
Again, I agree with everybody that's saying it is a little weird that he dressed like John O'Keefe. I think that's absolutely weird. But I do think using something of the same height and weight-ish as John O'Keefe to show that it is even possible for the taillight to line up with the arm is an important first step. Unfortunately for the Commonwealth, that's the only step really that they took and proved, because the rest of the stuff, just wait.
Trying to see if there's any correlation between all those.
Well, can body posture on a clip or a side swipe collision change the trajectory or the injury?
Of course.
Can the way somebody moves or reacts before impact change it?
Objection, Your Honor.
Yeah, and they ended up fixing a lot of this, Tracy. Both sides have done this, though. The defense has said Proctor at the medical exam or whatever. So it's like both sides have kind of done this with the titles.
What are other things that can change the trajectory of the person and the injuries?
So for example, if you get hit and knocked off balance or clipped and knocked off balance, you can take additional steps. That'll affect how far your body travels. If you have one foot on the ground versus the other foot on the ground, affects how the body rotates. If your arm is at 90 degrees or 85 degrees, will affect the kinematics. We attempted to model different possibilities, and we're getting results that were all over the map. Small changes in the pedestrian position give you huge change in the output. And so from the tech stream data, we don't know exactly when in the tech stream data he was hit. So we don't even know the exact.
Were you able to shatter the taillight with an arm and not make a tech stream event and not break an arm? Like, he's saying they did all these possible scenarios and everything was just so vastly different, so anything could have happened. That's fine. The issue is, how were those injuries caused? How was the taillight shattered? How were additional injuries not caused? Like, he's not answering the major questions that I think the defense is going to highlight. Rebecca said 16K in the chat, only 3.5K likes. We can do better. A little thing called membership happened when likes go up. Yes, everybody hit that like button if you guys haven't already, please. Hitting the like button lets other people come in, tell us what they think, get more opinions involved, and see if they see it this way or the other. Because to me, the more opinions we get from the chat, the more chance we have of hitting what every single juror might potentially be thinking, because they all are not thinking alike, just like you all in the chat are not thinking alike.
Exact impact speed. In most pedestrian reconstructions, you typically have a point where the impact occurred, like where the person was, like in the crosswalk, for example, and they get hit and their tire leaves a rubber scruff. That's called the area of impact or point of impact. You then can look at how far they were thrown and using some laws of physics, calculate how fast the car had to be going. Well, we don't have that in
But you have close enough. Like you have close enough. You have Jen McCabe's testimony. Where did she see the car? Why don't you put the car starting there, go 34 feet forward, however many, 87 feet back, and then you have Kerry Roberts and Jen McCabe that can tell you exactly where they found John O'Keefe's body. So you know where his body was. You can reverse engineer this. You can reverse engineer this and show how this could happen. I don't believe him when he said we don't have all this. Actually, I do believe him when he says we don't have all this, because I don't necessarily think all that evidence is credible either, but he should. And the evidence that the Commonwealth has presented should allow them to reverse engineer. That's what I've been waiting for so much. We have the injuries. We have where you say the injuries occurred. We have where the car was, how far it went forward, how far it went back, and where John O'Keefe's body laid. Please reverse engineer this and explain to me how this happened.
in this case. We don't know exactly where Mr. O'Keefe was on the roadway when this happened. Sorry, I'm about to go to the next slide.
But you know where his body laid. Because 2 witnesses the Commonwealth called saw him in the morning. And they say he was not moved or dragged.
Without having an exact point of impact or an exact speed or an exact body position, are you able to specifically replicate the actual collision in the way Mr. O'Keefe?
I thought we had the exact speed. I thought 23.9 miles per hour was the exact speed. Right? I thought we had that.
His body would move?
Exactly replicate? No. And again, in terms of how he would move, again, we don't know where exactly on the roadway he started. So in terms of how he moved, that's a function of where he started. We don't know if when he was clipped, he took an additional step before falling backwards. So that will change how far you are off the roadway. So the impact, which you'll see in a second, even at 2 miles an hour, will induce rotation of the body. So depending on the speed, the higher the speed, the more rotation. So if I may.
So again, honestly, obviously, I should say he spun multiple times because he landed on his back, they're saying, not on the front. And if it hit the side of his arm, you would think if you just fell straight down, you'd fall on the front. Again, I don't like doing this where like I'm trying to like build what happened. I like for the expert to tell me.
So slide 111, this is simply showing where I walk sideways, how this lines up with the location of the lacerations on Mr. O'Keefe's arm. Here's the post-contact scuffing on the taillight. Here's a picture of Miss Reed's vehicle on the right-hand side. So now I said, okay, that was me walking into the car. Let's have the car drive into me. I did this at very low speeds. And you'll see, and we'll show this from 2 different angles. That's me.
Like he puts the shirt on and then rolls the sleeve up, which tells you adding the shirt does nothing to, how effective this actually is, which is why you don't really need to be wearing his clothes, but whatever.
Showing, I'm doing test 2. This is from a camera that we have pointing.
I wouldn't want to get hit by a car going 2 miles an hour, right? Let alone 24.
Down at it. This is the speed. You'll see it's only about a 2 mile an hour impact. But even a 2 mile an hour impact redirects me back and causes me to rotate and take a step.
Yes.
All right. So they have again, another 10-minute sidebar here. We're going to come back afterwards.
When you were showing us this video, you walked to the side of the passenger side of the car, didn't you?
I did.
And why did you do that?
I was discussing with them what to do.
You were discussing with who what to do.
The driver.
In no way were you trying to imitate or give a demonstration of what you believed Mr. O'Keefe's movements to be.
Oh, no. This speed's just 2 miles an hour. I was having a discussion with the driver about what we needed to do to conduct the test.
So when you walked up to the passenger side, it wasn't to replicate a study or a movement or give an opinion.
No, that walking
simply-
had nothing to do with this case except for me instructing the driver what to do.
Thank you for that clarification.
Sorry about that.
No apology necessary. Could you go back to the beginning when you were explaining this so we can go through it?
So this is the dynamic test 2. So again, this is the view from behind. Just to avoid the confusion, I will start it here.
What speed is the car traveling?
You can see it. About 2 miles an hour.
Excuse me, Your Honor, that is the objection that we spoke about.
Oh, okay. All right, so that's noted, Mr. Larson.
So similar to the other test, this is the post-contact image of the transfers onto my arm. Actually, the yellow paint you can see from my hand is here. This is from the arm and forearm. Here's the paint transfer pattern.
And that slide number,
I'm
Dr.
sorry,
Welcher?
I'm terrible with that.
That's
Slide
okay.
116 now. It was 115.
Thank you.
Slide 116.
So a couple comments here on this demonstration. John said, "This is how I envisioned the accident when we first began investigating this case, but it was not presented to the jury in this manner during the last trial." Oh, I mean, yeah, people that are saying he was worse than Trooper Paul, I definitely disagree with that. I don't think Karen Reed meant harm, but I'd be worried about count 2. So again, John, my question to you would be, you're watching this happen at 2 miles an hour. Do you think it's reasonable, not possible, but do you think it's reasonable that, John O'Keefe's injuries were caused by shattering a taillight but it didn't break his arm. It didn't cause any other injuries. It literally just clipped him or sideswiped him, broke. So it was hard enough hit to scratch his arm. And that was it. And that's how the injury happened. And he spun and hit the back of his head. I definitely think that's possible, right? I just think it's highly, highly, highly unlikely with what I know in life, with my experience and logic and car accidents that I've seen. I think it's like 0.0000001% chance that maybe that polycarbonate was bad and it was weaker than normal polycarbonate, and John O'Keefe's bones were stronger. I just think that it's like you'd have to have all these outliers for this to be possible. And I think that that's kind of where I would be even after this expert. Now, he's not done, but those would still be the follow-up questions I have for you. I think that if he would have had like broken arm and like bruising here on the inside, a broken rib, some internal bleeding, whatever, then I'm with you. And I would have said, yeah, I think this is possible. I still think those cuts just don't look like they came from the taillight. And how did none of the taillight pieces end up like still stuck in there? But the debris on the shirt, you could say, right? I mean, there's definitely discussions we can have around this. To me, it's woefully short. Doesn't mean it has to be for you. Doesn't mean it will be with every juror. Adam said more likely a hung jury again or a conviction. I think if I had to guess, I'd say hung jury, which I hate doing because it's such a small percentage. But
16. What I've done is I've taken these yellow lines to show the extension of the components on the rear of the exemplar Lexus. Then I've done this extension of those same components on the rear of Miss Reed's Lexus and shown how the approximate location of the fractures in the taillight match up with the approximate location of the contact of the arm onto the taillight.
Dr. Welcher, do you have any indication of how Mr. O'Keefe's arm was bent, what angle it was bent at?
Not exactly, but for these to be taillight shard fragments, they would need to be in the area.
it's really every time I try to tell myself it's possible and you think about it, you just remember so many other things that make it so unlikely. So it's like it's possible in the realm of anything is possible to me. That's what I would say. It's possible in the realm that anything is possible with all sorts of outliers, but it is just so highly unlikely that I could never convict on the evidence that they've presented so far. I personally couldn't. And that's where I'm pretty firmly at this point as the Commonwealth is ending their case in chief. It's where I am. And I was really holding and waiting until we heard from Dr. Welcher. And I just thought it was so woefully short of what I would have wanted if I was the Commonwealth.
Of the taillight, but it could be further up. We know from the police photographs that there was a damage to the rear body panel in the area I'm searching here. So it's possible his arm was a little higher up and the glass hit the rear of the Lexus and caused that damage.
In the bottom right,
Excuse me, Your Honor, objection.
I will strike that last part about the glass.
Thank you.
the purpose of the
So many times he just like threw out his thoughts or what's possible. And this is a possibility. And it's like, you just can't do that, dude. You just can't do that. I'm not one for name calling, but he deserved some name calling throughout this as he forced some of that in there over and over again. Worst of all, at the end of the day today, which the judge struck multiple times.
The circle is for what, Dr. Welcher?
To show, in this case, primarily the location of the lacerations up on the arm, the upper part of the arm, and that they match up with the locations of at least the one remaining shard in the rear taillight of Ms. Reed's Lexus.
Looking at the picture of the Lexus, bottom right middle, are there any marks on the Lexus itself that you took note of?
Yes, on the next slide.
Thank you.
Actually, it's 2 slides. So there, again, this is the evidence marker. There was a horizontal scuff. We know Mr. O'Keefe had blue jean type pants on.
But Rebecca, the problem with this, so she said, very unpopular opinion. I believe John could have been leaning forward and throwing, causing lace, which is why there was vomit down the front of his pants and also causing laceration to his eyebrow. The problem with your theory is the Commonwealth has absolutely not even tried to prove that. So if you think that's what happened, okay, I don't know what it's based on, because then explain to me how he got the cuts, how he got the scratches. Where did the taillight hit if he was bending over? Definitely wouldn't have hit his arm based on, Dr. Welcher's own testimony. So I get what you're saying. And I think jurors will try to figure this out, like what happened, but I don't know how they would get there really. And I get what you're doing. You're taking certain facts and you're like, hey, you guys, the Commonwealth, you haven't proven a lot of these things, but I have a theory that might work better in there. Well, then there's other facts that you're not working into your theory. And that's kind of the difficult part when you are the state with the burden. People can say it's unfair about how I hold the state to such way higher bar than the defense. It's like, yeah, that's how the law is.
There's a scuff in the area that would approximately correspond to hip level for Mr. O'Keefe.
Next slide, please.
Yes, ma'am. 118.
Thank you.
Did you describe what you saw on the bottom right-hand corner photo as well?
I believe, yes, I did. That's the scuff that lines up with the approximate height of Mr. O'Keefe's right hip. So then I included previous image that you've seen, slide 119, with the reconstructed photograph of the rear taillight, showing where some of the fragments are. You can see where those fragments are.
This again, was to me just throwing stuff up there that Hank Brennan had entered in this trial and just saying words, but he didn't actually show or line up at all how those individual fragments could have caused those scratches on John O'Keefe's arm. He didn't at all line it up, which he could have, just like he did with the Lexus. Remember all the overlay images and the arrows pointing one to the other. And again, he's pointing one to the other here in such a vague way. In such a vague way. We have his arm. We know exactly where the scratches are. We know exactly how that tail light broke. You could see where each individual jagged piece is because they found most of the tail light, right? So I thought this could have been so much more effective than it was.
Are relative to the curvature of the tail light. They'd be in the area somewhat centered within the region of the 2 yellow lines on slide 119.
Is there anything about the photograph in the top right-hand corner that's important? If so, could you zoom in and show us?
So again, it's showing that this is when it's, I believe, in the Sally Port at the police station, showing that scuff on the right rear body panel.
Did you see any similar scuffs in the middle back of the car?
Objection, Your Honor.
Sustained.
Did you see anything notable as far as damage to the middle back of this Lexus?
The middle,
Yes,
like back where the doors are,
with the middle of the back of the car. Did you see any similar damage to the middle? or
there
the
were
left?
scuff marks that ran along the bumper.
Okay, continue, please.
So this is just showing his jacket he was wearing, that the puncture marks coincide to the marks on his arm. This is from the autopsy report. A couple things. It notes a 0.5 centimeter abrasion on his right lateral knee. He's got a laceration on his right eyelid. That corresponds to the height of that rear wind wing on the back of the Lexus.
Your Honor, I'm going to object.
Sustained.
Thank you.
How tall was Mr. O'Keefe?
Lexus of that rear right eyelid. That corresponds to the height of that rear wind wing on the back of the Lexus.
Your Honor, I'm going to object.
So he's saying that the eyelid cut came from the wing of the Lexus or spoiler of the Lexus. It was struck Why didn't Brennan ask the brain surgeon that? Why didn't Brennan ask the ME that? Why is this guy allowed to testify to that, but not the actual doctors who could prove how those injuries were actually caused? Again, I thought that was personally inappropriate, but it's in. How was his demonstration dress up stint not a chalk or exhibit that Bev has not allowed? She did allow it. I guess she thought it helped the jury. I do not think this is evidence going back to the jury. I think this was just a chalk or demonstrative aid. Netwoman. One of the many problems I have with the experts is they use the use of words like basically, technically, I believe, I think, and then can get a definitive conclusion of a collision from an automobile. I believe, because I'm an expert. The bruises on the knee was a defense from a dog running up. Here's what I don't understand. How did the car cause the bruise on the knee with a side-swiping blow, but not a dent, right? It didn't cause a dent right there, but it was hard enough to cause a bruise on the knee and hard enough to shatter the taillight, but not hard enough to bruise the arm on the same person's body with the same blood flow and both in the snow. Because I've heard some people saying no bruises because it was in the snow. Well, the bruise to the knee they're saying happened from the side swipe clip. It just doesn't add up to me. It's just the part. People can say, oh, you've changed and now you're biased. It's like, I'm not biased. Like, are jurors biased? No, they come in and they have to make a decision after the evidence is presented. That's the point. And I'm saying the evidence is being presented in a way that I don't think is lining up.
Object.
Sustained.
Thank you.
How tall was Mr. O'Keefe?
73 inches tall, 6'1".
And how high was that wing from the ground on the back of the Lexus?
It was about it's about 5 feet 11 inches, maybe 5 feet 10 and a half.
Thank you.
You're welcome.
Did you notice anything about Mr. O'Keefe's right knee?
I noticed there was a half centimeter abrasion on the right lateral knee.
Did you note how high from his foot that bruise was on his knee?
We don't know the exact length of his knee. The abrasion appears to be right here at knee level. If you go back and look at where my knee is, that would be at the proximate level of the bumper.
Could you focus in on the bumper to show it relative to the height of your knee?
Sure. Oops. So my knee is approximately right here. This is where the bumper is. So the side of Mr. O'Keefe's knee will be in this general area.
Okay, thank you.
You're welcome.
Sir, do you have an opinion to a reasonable degree of engineering certainty about the lacerations on Mr. O'Keefe's right arm and forearm regarding its orientation relative to the broken taillight on the defendant's Lexus?
Yes. May I read my report, my opinion?
So we're about to get to his opinion now, and this will be one of the issues we discussed. But Mary Smith said, I feel bad because I'm likely biased after Burgess, but I don't believe a lot of this is credible. This doesn't look believable to me. I've seen people hit by cars, no broken bones, doesn't add up. So you're right. You may be biased from Burgess. You may think everything Burgess touched now is not credible. That's something the defense is trying to do to create reasonable doubt and highlight the reasonable doubt in this case. So that is something a juror might think. It does, you don't have to be like, oh man, it's tough for me because I don't believe Burgess. So that makes me not believe that. That's how this works sometimes. It's how it works.
The location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX 570.
So that was it. That was his opinion. I'm going to back it up. We can listen to it one more time. This is it. This is the home run hit.
Defendant's Lexus.
Yes. May I read my report, my opinion?
Okay.
The location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX 570.
Did that convince you? I mean, you tell me if that convinced you. Oh, we're over an hour, so we're into overtime here. Everybody hit the like button yet? Everybody subscribe. Let's see if we can get 7,000 more subscribers, and we're at 500K. That's crazy. But we're going to go some overtime today because we've got a little bit more I want to get to. So y'all ready to hang for a little longer? Let me know in the chat.
After considering these three different subjects that we discussed, the tech stream data,
Right when I said that, a lot of the nopes came out from, did he convince you? It's like, no, 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 nope. It's like, you guys don't want to hang? You don't want to hang any longer?
Analyzing the touching between the defendant's Lexus and Mr. O'Keefe's car, and then your demonstrations regarding the injury to Mr. O'Keefe's right arm. Did you consider further evidence in reaching any conclusions as an accident reconstructionist and a biomechanical engineer?
Yes, I did.
Could you turn us to slide 124, please?
So this is some of the location of the physical evidence.
Which again, if we have this physical location of the evidence that you have, that you know about, that you know exists, that you know where it was, couldn't that have helped you reverse engineer this incident? Because, like, I guess it could have flown you could have a radius at least of where this stuff could have flown, right?
Red plastic, clear plastic. His point of rest was indicated to be 7 feet off the roadway. There was a sneaker that was found near the curb. There were various fragments of taillight found in the snow on the morning of the incident, actually the afternoon of the incident.
Could you zoom in on those photos so that we can see the dates?
The date?
Yes.
Oh, sure. January 29th at 5:46 p.m. This one's at 5:52. One's at 5:59. This one down here is at 5:46. So there were various fragments of the Mr. O'Keefe's right shoe way up.
And can you
I'm going to,
Head injuries from falls commonly occur.
All right. So now we're starting to talk about the head injuries.
Your Honor, I move to strike that.
I'll strike, I'm going to strike.
And fracture lines.
Once again, this is him getting one of his expert opinions struck multiple times because he's stretching way further than he should be allowed to. I would assume some of the sidebars were about that. We don't know because we didn't hear them, but that would be an assumption of mine.
Predominantly here, at least in the base of the skull. So in the biomechanical and forensics just means the legal related scientific industry, there's something called hat brim line or hat line analysis. And what it is it's looking at where the hat line you can imagine is where the brim of a hat would be. And what it is, it's literature that's looking at where head injuries from falls commonly occur.
Your Honor, I move to strike that.
I'll strike, I'm going to strike. I'm going to
Is that
strike,
removed from the screen?
yes, yes.
Thank you, Your Honor.
So that was slide 131.
No, that was 132. I
Oh,
moved it
sorry.
because you said take it out.
Your Honor, one more request to agree with this. Do not take that into consideration.
So Jerry, when I strike something, that means.
Which I also like this, that Judge Canoni is like, I've had to strike so many things with this witness. Let me remind you what it means when I say strike that from the record, which is important and not what you want happening when you're experts on the stand.
Do not take that into consideration.
So Jerry, when I strike something, that means don't pay any attention.
Thank you, Your Honor.
continue, Dr. Welcher?
So, Your Honor, I need to go past that slide.
Okay, go ahead, go past it.
This is the next slide.
Okay, if you can continue.
Sure. So I provided peer-reviewed scientific literature that looked at a metric where they were publishing research trying to delineate falls versus blows or assaults. And so this metric is in that scientific literature. They looked at a total of 400 different events, 235 falls, 165 assaults. And so you can see where it says mandible. So mandible is your lower jaw.
Can you enlarge that a little bit, please?
Your Honor, pardon the interruption. I'm moving to strike.
Yeah, let's take that slide down. I'm going to see you inside. Please.
Another sidebar. All sorts of issues with his testimony near the end of the day.
So it starts at the very top. You can see they analyze a total of 400 events, 235 falls, 165 blows or assaults. So what you do is you ask yourself on the first set of arrows, you look at the mandible, the jaw. And MRS, as you can see at the bottom down here, refers to a simple fracture or multiple fractures. A is no fracture. Mr. O'Keefe has no mandible fracture. So that means we go down this row. It then looks at all facial fractures. So these are the bones that constitute the face. So if you have a facial fracture, you go to your left. If you have no facial fracture, you go to the right. So if you have some event, no mandible fracture, no facial fracture, what they've indicated that is predominantly associated with falls and not assaults.
By the way, I'm just thinking about this from what he's saying, because some of the stuff is a little bit new, like the spoiler hitting him in the face and making that cut. That's it? 24 miles an hour, the spoiler hitting you in the face? That's the only injury it would cause? It didn't make sense, because it's not hitting your whole face, because the way it is, the way the spoiler sticks out, right? It just doesn't make sense. And once again, they just didn't dig into it. They just didn't dig into it. They want it to be purposely vague. So it's just like, again, I'm not saying they want stupid jurors or simple-minded jurors. They want jurors that want to simplify the case. And it's like, yes, this makes sense. Oh, yeah, okay, because that could hit. They don't want, if they dig beneath that, I don't know how you don't have some reasonable doubt. I don't. Carsto said, Peter, as of today, after their testimony, what is your verdict? Verdict is pretty easily not guilty. We have a ton of questions, so let me run through some. We don't know when, where, or how John O'Keefe was hit. Straight from the prosecution main witness. How can they end like this? So it doesn't have to be like perfectly exact, but give me the scenarios that end up where John O'Keefe was. And the Lexus taillight ends up like it was. And John O'Keefe could end up like the injuries like he had. At least give me something like that. Not like the measurement is what it is. Like, it definitely has to be more than they did. It doesn't have to be like a guaranteed perfect, this is exactly how it happened, and we have every single thing perfectly lined up. It doesn't have to be perfect, but it needs to be more than this. When we get to the Blue Man Group and Last Dance with the crash dummy Jane, do they have to turn over all the failed test data video to the defense? So usually they at least have to turn over all of the data from the testing to the other experts who can then look at it and explain what they found from the other data. Usually that's how it works. I don't know if it's different in Massachusetts. Strange credulity. Peter, I need help refreshing my recollection. If Brian Higgins' car was parked out front between the driveway and Karen's car, how did she go 50 odd feet backwards? Did I dream that? Again, you need your recollection refreshed, because I don't know. I don't know the answer to this, because one person said Higgins' car was there. One person said Karen Reed was right in front of them. They never really got confirmation. It's all very confusing about where the cars are. And again, the prosecution is just not going to mention issues in their case. They're not going to mention it. They're not going to call Proctor. They're not going to mention Burgess Education. They're not going to mention it. Michelle, do you see how the confirmation bias from MSP I influenced the assumptions this witness made in determining his findings? He based his work on the premise that there was a collision. That matters. I agree, and I'm guarantee Alessi's going to get into that. MAGA Barbie, my car beeps when I even remotely come close to a curb. I'm supposed to believe those alerts don't register in the database somewhere. Again, I don't know. Was there a triggering event when it was beeping and we know it was beeping when she was in the garage? There was one at 12:42 when the Lexus turned off. I'm very confused about the text stream data and what's a triggering event and what's not. MLC, experts said they tested different angles and results all over the place. Will the defense have those tests / results? Peter, did the witness just make, oops, sorry. I literally just started reading the next question. So it's the same question I answered earlier, that it should go to the defense experts. Pterodactyl. Peter, did witnesses just make the decision for the jury by saying the collision did happen? We haven't gotten there yet, but we will talk about it. I thought collision, no collision was the main question of the jury. No, I've got a lot of thoughts on this, and I will answer this, but I'm not so sure I see it exactly like Alessi. At the same time, I thought it was horrible that the witness did what he did. I think this was great presentation on direct examination. However, shouldn't we be concerned that the report from him and Burgess keep changing? It's concerning to me. I need to know on all three charges, the Lexus must hit John for any guilty verdict to court. I think the answer to that is yes. Now, could there be a technical argument made that maybe not? But I don't think the Commonwealth is doing that. I don't think the Commonwealth is going to argue that. I think they are admitting defeat if they say that. Hank said something that confused me at the end of the day. I must have missed that, but let me know what he said. I would be shocked if he argued that. Can the defense and ARCA mention the FBI hired them? No. I feel like they've earned the right after all the prosecution chaos. No, judge is not going to allow that. Linda K. Bowden says it's reversible error. She tried A. Hernandez in Massachusetts. Experts can't conclude like they did. Thoughts? What he said at the end of the day today, I thought was absolutely horrible. We're going to talk about that. We're going to watch the whole argument here together. But precision is not the same thing as accuracy, though. I agree, but just because it is also precise doesn't mean it's inaccurate, right? I think you'd agree with that. But I agree, every time something's precise doesn't mean it's also accurate. Why hasn't the defense mentioned the strength of the taillight? I think that's definitely going to be a main part of ARCA. But they don't want him to you don't want to ask this guy that, right? You want to ask your expert who's going to give you the good answer. Hank Brennan's ignoring it. Why? Because I think it's a problem in his case. Was the car measured when it was on? People are saying it's lower when it's off. I don't know that. I don't remember whether he said it was on or off, but I think that's a good point. He's standing behind it and moves his body out of the way, misleading. Can Alessi measure him in open court? Probably. Or he can ask him, did you measure that? How tall are you? Or whatever. I don't think he would do that. I don't. Mechanical engineer here. Did he confirm the vehicle instruments were calibrated and what their accuracy and responsibility was without both the data and motion analysis? Can't be relied on. I think Burgess did, but I can't remember. I think Burgess handled this part. Hey, Peter, didn't he say he reviewed reports from Dighton? I thought the car never went to Dighton and was instead taken to Sallyport. Thanks. Honestly, that specific detail, I don't remember. He said he reviewed a lot of things, so I don't want to give the wrong answer on that. Peter, if the defense calls Proctor, can the Commonwealth prepare him for testimony as if he was the Commonwealth's witness? Yes. Let's go. Would it be reasonable to take from this guy that John was drunk, walked into the slow-moving car, and then the doctor's testimony that he slipped and fell and hit his head, not guilty on all charges? If the car hit him because of Karen Reed's operation of the vehicle, then I believe either a lesser included on count 2. I think a lesser included on count 2 could still apply, potentially. I think count 3 has a knowing element, if I remember correctly. I've got to read the verbiage again. How could she hit him on the 3-point turn, but turn before Fairview when the Commonwealth's own witness said they saw the car when they turned onto Fairview? They are not saying the collision occurred on the 3-point turn. How can he testify to the injuries even though he isn't a medical doctor? He's testifying that the injuries are consistent or not consistent with the car, not that he's not doing causation of the injury specifically, but the judge is allowing him to say, I think she's going to allow him to say these injuries are consistent with being hit by a car and are at the right level measurement wise with the taillight. He's already said that portion. If an expert witness is hired, but the lawyer doesn't like their findings, do they have to use them still? No. MT, height and weight does not equal the exact dimensions. That's true. That is true. Some people have longer torso, longer arms, shorter arms, longer legs. That is true. Using a dummy to show how things line up is improper. Some judges and jurisdictions do allow things like that. If he wants to be accurate, he could have gathered JO's dimensions, example, arm length, forearm length, shoulder height, etc. I don't know if that is still available. I don't know that they took all those measurements. Actually, I'm pretty sure they did not take all those measurements prior, but I don't know if the ME did. I don't know. I'm fuzzy on some of that. Mike, even if you believe she hit him with her car, has the Commonwealth made any case for intent whatsoever? In my opinion, absolutely not. I can't imagine a world in which she's found guilty of second degree. I agree with you. In fact, I think they've proven the lack of intent. If he was trying to correlate it with John's cell phone data, why did he ignore the data that showed he climbed 3 flights of stairs? Well, he probably also looked at Whiffin's report where it said that was going up and down hills and decided to, just like he said, I consider all evidence, but I don't consider it all credible. He probably found Whiffin's testimony to be more credible than others, and it is what it is. If Karen recklessly backed up and John O'Keefe stumbled and fell to get out of the way without making contact with her car, would that still fall under manslaughter? I think it possibly could. If her maneuvering the car caused him to, move, trip, fall, and die, I do think that is possible, yes. All right, let's listen to a little bit more of his testimony before we get to Alessi's arguments at the end of the day.
Thank you.
You're welcome.
In addition, did you do any further study on the force of a person falling back and landing on their head?
Oops, I did.
Could you
So what I did was I did what are called drop test. I took an anthropomorphic test device, ATD, which is just a fancy name for a crash test dummy, and dropped it backwards onto a hard surface to look at what happens if you were to say fall backwards and hit your head onto a hard surface. So on this particular,
Why didn't you have it hit a crash dummy's arm at 24 miles an hour? Why did you not do that?
photograph of Mr. O'Keefe in the upper left, there's noted to be abrasions above the fracture line in the area. You can't see that at all. You can see noted to be abrasions right here. Your Honor, I brought a hat. That was the one I used in my testing. May I put it on and demonstrate something?
Mr. Alessi?
Head hits the ground. It creates kind of an arc path that will drag and slide objects up the head. So if you have something such as a baseball hat it'll cause it to drag across the scalp, dragging it up to a similar location to where these abrasions are. So here's the testing. Again, this is it's crash test dummies you see on television. This is myself. Me giving me similar instructions, telling them what we're going to do. I said, and watch. Shoulders come in, then the head contacts the ground. What you see is if you fall backwards and land on a very hard surface or hard surface,
You know what didn't happen in that demonstration? He wasn't flying multiple feet and hitting with extra gravity pull. He's just falling from standing up. Could have slipped and fall, trip and fall. I know there are issues with slip and fall, trip and fall, but this does not disprove that. And that's something the Commonwealth needs to do.
will get extremely high loads on the head. If you compare that to data in the science,
I'm sorry to interrupt.
Yeah.
Please explain what the chart is before you explain.
oh, sure. This chart up here.
Nope, the next page.
Right.
You can largely tell us what it is before you get into it.
So what you see, the portion at the back of your skull is called the occiput bone. So that bone, if you put your hand in the back,
You know, a lot of people had a lot to say about that, but we'll just go ahead and just roll right through it. It was just a misstatement by this expert. And I highly doubt the jury picked up on it.
your head is your occiput. So we're looking at occiput impacts. And what you can see is that when they took cadaver skulls and dropped them from as low as 40 inches onto a hard surface, they were getting linear fractures. And you can see even at 40 inches, there was called a stellate fracture. Stellate means star-like. You get a fracture that goes out like a star. So even at a 40-inch drop height, you have sufficient force when landing on a hard surface to cause skull fracture and a level 3 type skull fracture. So Mr. O'Keefe, again, is 73 inches tall. His occiput is about 4.6 inches down from the top of his skull. That means it would fall a total of about 73 minus 5 would be 68. So just under 6 feet. So 72, 4 inches under. So 5 foot, 8 inches is the fall height. What is data showing that?
Too many numbers here again, where I was just like, buddy, you've got to simplify this. You've got to simplify it. It's got to be easier to follow. This is not easy enough to follow. Like, this stuff should be easy, but just when you start just throwing number after number after number after number, it gets confusing.
Even at a fall height as low as 40 inches onto a hard surface, you can get fairly severe skull fractures.
And again, I think that's good for the defense. Could have happened inside. Could have been an accident. The dog could have jumped him. Another animal could have jumped him. He could have slipped and fell from being drunk. Like, it just leaves all the this is not eliminating any possibilities. Frankly, they already had this information. I would not have even asked this expert these questions personally, to keep it simple.
Thank you. Dr. Welcher, regarding your third part of your analysis, did you come to a conclusion to a reasonable degree of engineering uncertainty whether or not the defendant's Lexus collided with Mr. John O'Keefe?
So this is his first attempt. Did the defendant's Lexus collide with John O'Keefe? There are some issues. There's an objection. He eventually gets to do it again. So we're going to jump to when he does it again, when we can actually hear it. And this was one of the most frustrating parts of the day to me today. It's just frustrating. He's obviously a skilled witness, a professional witness, a professional expert. So for him to do something like this is different than just a lay expert to me.
Okay.
Okay, Dr. Welcher, let me ask you again. Based on your analysis, data available, reviews, study, based on the fact that you are an accident reconstructionist and a biomedical engineer, have you reached an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus struck Mr. John O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes.
And could you share the bases of your opinion before I ask you your ultimate opinion?
Sure. So again, you've seen my slide presentation. I've inspected the Lexus. I've looked at where it wasn't damaged.
I've inspected the Lexus was the number one first thing he said, because they want that differentiator from ARCA.
I've inspected the taillight. I got an exemplar Lexus. I ran lower speed contacts to verify that the injury pattern and location on the arm is consistent with the height and orientation of the taillight.
So there he said the injury pattern on the arm. I do not think he came close to showing us that the injury pattern on the arm is consistent. Now, the height and location, I think that is consistent. The pattern is what just blows us out of the water. It's one of the many things. But he's just saying it as if it's true here. And by the way, this is not what I have a problem with. This is what I expect an expert to do so far.
I have looked at fracture tolerance data for falling backwards onto hard surfaces. I've looked
fracture tolerance data for falling back on hard surfaces. What you didn't do is fracture tolerance data and testing for the arm getting hit at 24 miles an hour by a polycarbonate taillight. Why not? You can do it. You just said you could do it. Put your back into it.
looked at the metrics of where his injuries were and what injuries he didn't sustain. I've looked at the cell phone data, and then I've looked at Miss Reed's interviews as well.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
Oh, to
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That
Okay. So his first answer, I was perfectly fine with. I wouldn't have called him a schmuck. Okay. But wait till we get to the end of the answer.
yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable.
Fine. That's what an expert is supposed to say. But then he continues, which is, this is the stuff where when I'm a lawyer in trial, I look at the judge and I'm like, this is exactly what we can't have happen, Judge. So what am I supposed to do? I have to tell the Commonwealth to tell their experts to not say what they know is wrong to say and they can't say? Because Brennan's question, there's an issue with it. We'll talk about what Alessi argues. And, I understand. I would make the same exact argument Alessi would, but some judges I know I would lose that argument with. But this line right here is the problem. And even Judge Cannoni knows it because she immediately strikes it.
Totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
Objection.
DNA, fine. We can talk about DNA. I know a lot of people saying DNA. That's fine. He said DNA. We didn't hear anything about DNA. We'll hammer on that, unless he can hammer on that if he wants to. But to say to a reasonable degree of scientific certainty or engineering certainty, that is what happened, buddy, you can't say that. You can't say that. Does Commonwealth pay extra for you to slip stuff like that in? Like you can't say stuff like that. I'm kidding, obviously, about the Commonwealth paying extra, but you really, really can't say that. We'll listen to it one more time. And immediately, Alessi asks for it to be struck, and the judge strikes it. That's how you know.
Everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
Objection. Move to strike, Your Honor.
So I'm going to strike that. I want to see counsel's just.
We're going to strike that, and I want to see counsel at sidebar. So he won the objection, and she still wanted to see them at sidebar. Judge Cannoni, everybody in the courtroom knows that's a problem. Everybody. And I hate it when stuff like that happens. And by the way, that right there is the last thing the jury heard before they left for the day. That he gave by the way, Brennan said he's not completely done with this guy, so that's fine. So there's still more from him. But the last thing they heard was him give what seems like his final opinion. And then they heard the judge say, strike that, after the judge earlier in the day said, when I say strike that, that means you can't consider it. It's not good. And then they send the jury home for the day, and we get Alessi's arguments on the issue.
Let's go ahead, Mr. Alessi.
Thank you, Your Honor. The point number one is the question of.
Actually, before we get to Alessi's arguments on that, let's answer some more questions. When I'm in reverse and I'm about to hit something, my car warns me. Is there a record of her car warning her of an impending impact? It seems like the answer to that is no. JM said she saw the car pull forward and reverse, so that doesn't corroborate what he's talking about in the slide a few minutes ago. No, either she saw the accident happen, right? Or it was another event that wasn't picked up as a triggering event, right? There's a lot of explanations. I don't really know. The slides and pictures are nice and all, but Peter, honest opinion, do you really think a collision with a human wouldn't be a triggering event? I think it could, or I think it couldn't. I think at 2 miles an hour, if it was like his demonstration, I think it's possible that's not a triggering event. Absolutely. As Andrea pointed out, shouldn't there be paint on his pants from the scuff? Yes, but I don't think he put paint on his pants, did he? Or on the bottom part of the car. I wonder why. I think that's a great question. Peter, for an expert testimony, do you think there were too many ifs? Yes, especially for a Commonwealth. If I'm the defense and they put some possibilities out there, I'm okay, because we can make them, if they're reasonable enough, reasonable doubts. Didn't the brain surgeon say be incapacitated if he was hit in the street? How did he end up on the lawn? I would guess fly multiple feet. They're just leaving that open as a possibility, but not showing us what that would look like in one of their many demonstrations that they did. I would argue why he didn't paint the bumper to show possible contact with John O'Keefe's legs. Yes, multiple people have that same thought. How did he get to the Lexus struck him if he didn't know so many variables? That to me is the definition of reasonable doubt. Was hoping he would exactly explain how it happened and change my mind. It didn't have to be like perfect exact, but at least show me, okay, this is probably how it happened. And then let the defense pick apart some specifics, fine. But at least we see how an arm could shatter the taillight, not break the arm, make those cuts without, the huge jagged pieces still being stuck in his arm, and how he would fly back, hit the ground, be incapacitated. Show me how that happens. He didn't seem to believe his own theory. He said, we don't know exactly what happened. Then why should the jury? And again, there have been cases like that where it still can be a winning argument because the other evidence makes it so obvious. It's almost the opposite here. To thine own self be true. Be you, Mr. Tragos, and I always will be. I always will be. Sometimes that's good, sometimes it's bad, but I always will be. Peter, have you used this flow chart? It's like a choose your own adventure. Chat, hit the like button to thank Peter. It feels that way sometimes, doesn't it? Bethany, can you explain how he was hit behind the car at 24 miles an hour that traveled 87 feet, but ended up in the front lawn, 30 feet in the yard? I'm trying to understand their theory. They did not show me. And that's what I'm saying. I don't play the role of figure it out. I've got to be detective. If they don't even show me how any of that seems like it could be possible, if I'm a juror, that's why I'm saying I'm not guilty. I don't know what happened. I don't feel confident really in saying which one of these theories happened. I really don't. How does a spoiler hit the face and the taillight hit the arm to shatter it at the same time? He said it's the same height, and I guess that's all you need to be consistent, right? Can Cross ask him how often he testifies in court? A lot. Then why are you reading report expressing inadmissible statements, etc.? Well, they're not lawyers, right? They're not lawyers. And, a lot of experts may not know exactly what's admissible or what's not. But why does Bev need time to think on that is what happened? Isn't it 100% not allowed for a witness to say that? What is there to think about? Yes, she's not going to let him say that is what happened. We'll listen. This is a good segue into the arguments about what actually are they arguing about here.
Whether, based on reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was...
I think that's a good argument. I think that's a good analogy, but I think it's a little bit different. I also 100% agree that the questions Alessi is going to say Hank Brennan should ask are the appropriate questions. Some judges let prosecutors go further than that, but these are the appropriate questions, and these are exactly the questions that they want to ask ARCA.
Was a collision is the ultimate question for the jury. That is why we are having this trial. The defense strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement.
And Brennan is going to have something to say about that. Insomniac said, this punch landed. I hate the prosecution, but hats off. I think manslaughter is the verdict, but waiting for Alessi and the other Avengers. Okay, so there are some people that thought this was good testimony. And at the end of the day, I think that it's possible. The jury's like, okay, that's simple enough. The taillight lines up with the arm and, okay. I would hope not, but it happens. I'm telling you, it happens. We'll see what Alessi can do with him on cross. And by the way, it's not over. Brennan still has more direct.
This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury.
I agree. He can't opine on the ultimate question, but what is the ultimate question? Is the ultimate question actually, was there a collision? Or is the ultimate question that Karen Reed hit John O'Keefe with her car, either intentionally or recklessly, in an event to cause some kind of manslaughter or killing, right? That's the ultimate question. So how far is a judge going to allow somebody to enter that? I think Alessi is right. I think the way his argument is right, but I have seen judges allow certain kinds of questions similar to what Hank Brennan is asking. Never are they allowed to say, that is what happened. To a reasonable degree of scientific certainty, that is what happened. It's consistent with X, Y, or Z is what's appropriate. And he even said it the first time he answered. The expert even said it the first time he answered, so he knows.
I accept, subject to evidentiary issues, the two questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So what Mr. Lisi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was no collision, over and over and over again. And he just told you that.
It's like, buddy, lawyers' arguments are not invading the province of the jury. That's what we do. We tell them our theory and where the case is going to go. So yes, exactly. We are telling them what did or didn't happen and telling them how to vote. You do the same thing. You said she's guilty. All the evidence is going to say she's guilty. That was a horrible argument by him. Okay. Even though I do think some of the questions he asked, judges will allow that, right? But that argument was like, you did the same thing. Every lawyer does the same thing. Now, what he's saying is lawyers do that because they know that that is allowed by expert witnesses. And while I disagree with him, I think he is definitely going to be able to ask something like that to this witness at the end.
When his expert case stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or
Oh, they have no case law? Just wait, unless he's got some case law for you.
jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an active reconstructionist. He studied the tech stream data. They didn't, he did. And he's entitled to give an opinion. The tech stream data, based on fact and science and data, tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the text.
Well, I don't agree with the analogy to the opening statement. He's right. He's allowed to ask questions around that. But again, he definitely can't say that is what happened, but he can say that's consistent with the car accident, which unless he knows that he is allowed to testify about that too, they're just kind of arguing semantics about what question can be asked and what can the expert actually say. The judge is going to have to come up with something that, whether they agree with it or not, that's how it's going to come out.
Same data, the physical evidence is independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe. And he's also allowed to answer, in his opinion, the issue of a collision, putting aside the fact that that was emphasized and repeated in the opening statement and it's going to happen again.
Yeah. Tom the Great said the scratches are oriented 90 degrees off in his own theory. Yeah. Even the way he bent his own arm, the scratches would not have looked the way they looked. And that's technical. And unless he's going to have to get into that on cross, and you got to be careful and methodical about how you do it. Don't make it too clunky or too confusing.
Again, when other people testify, it's not our fault that ARCA didn't testify or look into the tech stream data or they don't have an expert for it. It doesn't belittle or limit that evidence.
It's not our fault. Our experts are better. That's what he's saying.
We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022 around 12:32 a.m. That is one of the opinions we're going to ask him. nothing to do with the ultimate opinion of guilt or innocence, or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you
I
looking
will
at?
also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between a clip or a side swipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper. And there are further slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
Consistency with a side swipe or a clip.
okay, so this is not the end of Dr. Welch's testimony. He's just moving on to another area.
So before we talk about the other area, there's a couple questions here that I think are good. John said, I'm not sure the jury picked up on his actions here, though. I wouldn't realize it before learning from the lawyer, just being honest. I think you're right. And I'm not saying that they know it. I'm saying me as a lawyer and him as an expert, you have to know that. The judge knew it. That's why it was sustained immediately. That was the frustrating part. Because I don't even think Hank Brennan's question elicited an answer like that. He forced it in. Bob Jr., but they heard it. So the ones that did hear it and it did affect them, just because it's stricken, you're right, Bob, sometimes you can't take away the effect that it has. And that's why it's so important. And potentially you make a motion for mistrial. I don't know. I don't think it would get granted, but we'll see.
Yeah.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's the case. Attorney Brennan said, go ahead, case. Well, here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands for the proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have
Leslie's like, we're going to ask the exact questions I said Brennan should ask to ARCA.
the ARCA report right in front of me. And I have the report.
Is that a new one or is that a?
This is the new one.
Okay.
It's also, the old one is the same. So either one is the same. They do not, Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision or conclusion. It's consistency. So those two questions I said in sidebar. And for reference, Your Honor, for the most recent is page 15. There is no.
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARCA's existing report, which I'm going to do from memory. I think it's February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said they gave opinions on those two items I spoke to you with sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
And that's what they asked the ME. Is it consistent with this? Is it not consistent with this? That's exactly how it's gone this entire trial. And those are the appropriate questions, but sometimes you're allowed to push a little bit more. Portia said opening statements show what's to come and then present evidence, right? Yes. Yes. But sometimes lawyers argue in opening statements. Alessi Never Sleeps said, watching Lawyer on my honeymoon sounds like I missed a crazy afternoon. You know what's crazy about this? Marissa J., if that's your name, you are not the first person to tell me they've listened to these videos on their honeymoon. How wild is that? I was like, man, that's some interesting honeymoon listening. And you're a new member. Welcome.
All right. So we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today. All right. So I'll see you in the morning.
All right.
All right. So that is what happened at the end of the day. And again, I think Alessi is trying to kind of force the questions he thinks are necessary. I do think they are the proper and correct questions, but I think, judges usually let them push maybe a little bit more than that, but they cannot say that is what happened. That's what happened. They have to say some form of that is consistent to a reasonable degree of medical probability. The car is consistent with the injuries or whatever. They have to say it like that. Hopefully Judge Canoni doesn't completely blow that. He keeps saying that John was hit and struck. Won't that sway the jury? It can, even though the judge struck it. KW, can the witness use Burgess's cell phone accelerometer to determine how fast and when he logged into LinkedIn to delete his CV? So it's like kind of like the emails that Welcher was saying he was getting about Burgess's CV and the issues therein. It sounded professional at the beginning, but then it took a turn. Misfit Joy, thanks for the OT today. Did this expert address the lack of blood at the scene? No. Head wounds bleed. I've been wondering that for a year. He did not address any blood or vomit or anything on John O'Keefe. He didn't address a ton of things. And I think that the Commonwealth's being strategic. I think they're going to let the defense say stuff about it first, and then they're going to hit a lot of this in rebuttal. Where's the chat for injuries from fall / plus being hit by a car? Where's the chart for injuries from fall plus being hit by a car? It's a good point. Is he supposed to be the end all be all in this case? I think he is. I think he's supposed to be their star witness. Since Brennan asked him if he testified for the government, can the defense ask ARCA the same question? So yes, they will say they testify for the state, for the government, even maybe for the DOJ. I think that's fair. I think they should be able to say that they testify. They've worked for the DOJ and the federal government before too, but they're not going to be able to connect it to this case. Why is it not allowed to say 100% certainty? Because they're not 100% certain, and no good witness will. And that's what thank you for asking this question, because it reminded me of the other annoyance I have is the good witnesses. Thank you, Truly Laws, for gifting 5 memberships. And Rebecca for gifting 10 earlier. The good witnesses that are experts, and we've heard them in this case, are like, okay, I can't say that, but I can say it is with, structural consistency, whatever. Like even the people that put the taillight back together, they wouldn't say, yes, it's a perfect match. Yes, all this worked out perfectly. They use specific language to testify to as much as they can testify to and not more. That's a big problem when people try to push and testify to more than they should be able to, because this guy can't say what happened. He already said that 100 times, but he can say it's consistent with a car hitting a pedestrian. That's as far as he can go. Thank you, Rebecca, for hanging, for your questions, for your comments, for gifting memberships. Lisa, if I stand facing my rear passenger side, my left side is what gets sideswiped. If the passenger taillight hits me on the right side, I am standing all the way behind the vehicle's right side. It doesn't add up. Michelle, do you think Hank told him to say that's what happened? I don't think so. I really don't think so, because other witnesses haven't said that. Math major here, numbers are not just numbers when they're being assigned a meaning based on assumptions. I also took anatomy and physiology 1 and 2. This guy wasn't it. I really think that's going to depend person by person. Tamara, how was the right taillight broken by the right side of his body? If he was facing the car at impact, wouldn't the left side of the body, wouldn't it be on the left side of the body, right? The way he showed it, I mean, it was definitely right side of the body on right side of the taillight. Maybe I'm missing something as part of your comment. Reasonable degree of scientific certainty is a non-quantitative term, which sounds great, but just means something is reasonable to believe it occurred and is not the same as it actually happening. I agree, but it is what we use with experts to make sure junk science doesn't get in, and they can't say what actually happened with 100% certainty. Nobody can say that if you weren't there. Now, eyewitnesses can say what they saw and what happened, but not people doing tests like he did. But this far in, arguing what trial's even about. It's a problem for the Commonwealth. Aperture company name over how apropos variable gaps. Could the defense subpoena GPS records for the Ford Edge to determine when it arrived at 34 Fairview? If they could have, they probably would have to do it a long time ago. I don't know if they still exist. Jen's Nefarious 5.07 call to Coco. Judge said he expected J.O.'s car. Did he know Jen or Carrie testified that a repair guy had been at John O'Keefe's home the day they dropped the kids off and visited Tully? I don't know that answer. Feels rhetorical. We'll see if the defense brings it out. Alien Superstar. Can she strike his testimony entirely now? No. Since he is clearly a seasoned expert but has so many objections, or does it not rise to that? No, it does not rise to that. What are possible remedies to this issue? She forces him to ask the question Alessi wants him to ask. Alessi's not saying strike the whole thing. Alessi didn't ask for a mistrial. He said he needs to ask, is this consistent with a car accident? Which I think would be the proper remedy. She might let him go a little further than that, but that's the appropriate remedy. Hey, Peter, thanks for working hard. We appreciate you. Thank you, guys. Are you growing your hair to give it to cancer treatments? If you are not, it's my theory. It looks good. Thank you. No, I'm not, but thank you. Maybe if I do cut it off one day, I will do that. How can Brennan say the ultimate question is guilty of count 1 or 2? Not guilty question. Well, if they're not guilty of 1 or 2, then they're not guilty. I guess you're saying they might just not answer, but I think we all get what he meant. Wasn't it odd to list aperture on all sides? I don't know what that means. List aperture on all sides. Manslaughter, check. The amount of evidence planting needed to think otherwise is beyond unreasonable and frankly absurd. So that's Sean's position, that they think, or he thinks that the Commonwealth has proven manslaughter. So Sean, you don't have to, obviously, but how do you reconcile the arm injuries with the enough force to break the taillights, but not more injuries to the arm, and how the injuries look? If you want to, if not, that's just something that's a hang up in my head. And if we were jurors together, we would have to talk through that to see if we can come to an agreement. Bettero said in your weekend combo that Aperture had affiliations with MSP. It's known that the supervisor of Trooper Paul's unit was hired by Aperture in June after being at MSP, too many ties to the DA. Alicia, the Commonwealth hasn't proven anything yet, in my opinion. I disagree they haven't proven anything. I don't think they've proven a crime. Waiting to see the evidence that John O'Keefe was hit by a car. Patricia, so he did say Karen would have to be going 39 miles an hour to John O'Keefe's. I may have missed that. Did he say 39 to make it 6 or 7 minutes? 6 or 7 minutes still doesn't add up from 132 to 136 though, right? Mia's Dolphin. Can jurors look up companies in trial people? No, they cannot do any research about the trial, including look up experts. They cannot do that. Okay, I've got to run. It's too late. I got to get home. I got to eat dinner. I'm starving. I got to use the bathroom. You guys are the best. Thank you for hanging out with me. Please hit that like button and please subscribe if you haven't already. Like a third of the people that watch don't subscribe. If just all of you guys subscribe, we will hit 500,000 before the end of the week. I appreciate you guys so much. I love hanging out with you, even when we disagree. I'm glad we can have respectful disagreement and conversation and debate on this channel, and let's continue to do that. Lacey, last question here. I think the pressure and the cold could have still cracked her taillight. Personal bumper-to-bumper accidents have shown damage to my car and to others. Just because there was no damage to John O'Keefe's vehicle, I think that this could be a good thing for Aperture experts to discuss. How maybe they become more brittle in the cold. I would like to hear that. All right, I got to go. You guys are the best. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.